welcome to today's Bloomberg B&A webinar. I have just a couple of announcements before we begin. First of all, thank you for attending today's presentation. Questions will not be submitted by telephone. Questions may be submitted at any time via the Q&A pod at the lower right of your screen. Simply type your question and click the icon to the right to submit. Questions will be allowed to accumulate and will be addressed towards the end of the presentation. You will currently see instructions on how to earn credits for attending today's webinar. If you have any questions about continuing education credits, please email us at credits@bna.com. In order to obtain CLE credits for attending today's presentation, you must answer all polling questions that are presented throughout the webinar. There is no submit button for multiple choice questions. If you would like to receive CLE credit for attending today's presentation, please make sure to answer the polling question at the end of the program accurately, which will ask for the jurisdiction where you wish to receive credit and your corresponding bar number. Your certificates will be ready to download in your classroom at learning.bna.com in the My Certificates tab generally within 1 business day of the presentation. Instructions for downloading your certificate and a copy of the presentation can be found in the Files pod to the right side of your screen. Before introducing our speakers, I would like to thank World Services Group for sponsoring today's webinar. World Services Group is the most prominent global legal network of leading independent firms. With over 145 jurisdictions, 19,000 professionals, and over 130 member firms, WSG offers immediate access to distinguished professionals and firms recognized within key industry sectors globally. I would now like to introduce the speakers for today's webinar, Ensuring Data Protection and Cross-Border M&A. Lisa Soto chairs Hunton & Williams' top-ranked global privacy and cybersecurity practice and is the managing partner of the firm's New York office. She has received widespread recognition for her work in the areas of privacy and cybersecurity. Alan Konevsky is Senior Vice President and Strategic Initiatives Counsel at MasterCard. In this role, he has global responsibility for providing legal and strategic judgment, guidance, and oversight for mergers and acquisitions transactions, integration of acquired businesses, investment portfolio monitoring, and other critical projects. Jake Hornreich is a principal with Skoda Minotti Risk Advisory Services. He brings over 9 years of information technology security, auditing, and consulting experience to his clients. Philip Kemperman is a partner at Heuking Kuhn, a major German independent law firm. With more than 300 lawyers, the law firm has full-service approach, including, in particular, construction, general, corporate, and commercial matters, M&A, and international arbitration. I would now like to turn the presentation over to Lisa.
Okay, thank you very much. I appreciate it. So events during the last several years have really thrust data protection in M&A transactions squarely into the spotlight. While the need to focus on these issues in the context of a deal is not new, what is new is the recognition of these risks by the broader community of transactional lawyers. And certainly in the era of big data, where information and data is the lifeblood of many organizations, it is imperative to address global privacy and data security issues as a key deal point. A failure to consider these issues in today's context, which really might change the pricing of a deal or kill it altogether, is simply unacceptable at this point in time. So why does this issue matter? Personal information is a critical asset and really is, in many cases, the key value of an entity that is subject to a transaction. And just to give a quick example, when Facebook acquired WhatsApp, they bought it for $19 million, and when you translate that cost, that's about $30 for each of WhatsApp's 600 million users. So that gives you a sense of the value of data. But global privacy laws may in fact not allow you to access the data or use the data or transfer the data in ways that you would expect you could. So it's critical to understand the constraints in advance of engaging in a transaction. We're going to talk today about many of these constraints and also give helpful pointers about how to, I hope helpful, pointers about how to manage data in a cross-border M&A transaction. And we'll talk about very significant data transfer restrictions in a number of areas around the globe, which means that data can't necessarily travel freely from jurisdiction to jurisdiction without jumping through sometimes very significant legal hoops. We'll also talk a little bit about data localization trends, which a number of countries are now putting into place, such that data needs to remain in country, or at least the initial version of the data needs to remain in country, and then data transfer restrictions would apply to the movement of data. So these are significant constraints around the movement of data from jurisdiction to jurisdiction. This is a map that helps to highlight where there are comprehensive data protection laws in place, many of which embed data transfer restrictions and some of which impose data localization requirements, and all of which impose significant obligations that need to be focused on, to really be honed in on in the context of a cross-border M&A transaction. So what you're seeing in blue, and this is a little bit dated, but still a very good representation. In blue are areas of the globe where there is comprehensive data protection legislation in place. In red, these are pending initiatives, and we absolutely know that these are countries that are moving or have moved toward having an omnibus data protection law in place. And interesting, very interesting from my perspective, is in white, it shows jurisdictions where there's no data protection laws in place, and glaringly white, of course, is the United States, and that's absolutely a mischaracterization. There are, in fact, many privacy and data security laws in the United States, and it's a bit of a patchwork quilt, so it's not easy to interpret the U.S. laws vis-a-vis a global perspective where there's a comprehensive law in place, one law in place in many jurisdictions. But there are very significant rules around the use and protection of data that can have a devastating impact if not well handled in an M&A transaction. With that, I'm going to turn it over to our EU colleague to talk about the EU.
Yes, thank you, Lisa. You're quite correct. As Europeans, as we have a horizontal approach on data protection, where one data protection law in each country, or in the future GDPR, protects all personal data regardless of industry sectors, always think or tend to think that the U.S. don't have data protection laws, and I know this is not the case. And in some cases, the law is actually might be more restrictive than in Europe, but that's at least the European perception. And the foreign perception of Europe right now with the GDPR probably is, ooh, what is all this stuff that Europe now invented or brought up in data protection? This is the GDPR that most of you probably already heard of and have had countless seminar options and everything to listen to. And I'm not going too much into detail on GDPR today, but you should if you're doing business in Europe, or if you're intending to do business possibly by acquiring a target there. Basically, the GDPR, General Data Protection Regulation, protects personal data of any natural person. So that's going to be any data that's identifying, like a name or an address, or potentially being able to identify a natural person. So as some of those examples of potentially identifying natural persons in Europe or under GDPR is IP addresses that might be personal data or are considered personal data by the highest European courts. So it's really, can you identify a person? Then you have personal data, and then you will be in scope of the GDPR once it comes fully applicable in end of May 2018. GDPR does not protect legal entities, so any listed companies or capital share companies, they will not be protected generally by GDPR. Some member states in the European Union do have protection for legal entities as well, which for instance would be Austria. There's some debate going about that. Or not a EU country, but still a European country, Switzerland also protects legal entities. So if you look at the topic of personal data, you will always have to look, despite the unifying approach of GDPR, have a look at what country are we talking about anyways. As I already said, the GDPR knows a horizontal approach, so it's not sector-specific, but all sectors are included. Very minor exceptions, like the telecom sector, that still has their own data protection regime. Under the GDPR, any use of personal data is generally prohibited unless a legal permission exists. So typically when I speak to people from across the pond, it's, oh, I don't worry about that, I have consent. Well, consent is one of the main permissions under the GDPR. It's not the most practical one, actually. You usually would like to look more into permissions for execution of contract, if personal data is necessary to execute a contract. Legal requirements, such as compliance and anti-fraud requirements. For transfers, for instance, between the potential target in Europe and the headquarters in the US for Sarbanes-Oxley reporting, that might be the right permission to go to and not ask for consent from the data subjects. Another very important and very interesting permission is legitimate interest. This is something where you balance the rights of the data subjects with your own interest in using their data, and if you get a positive balancing assessment in the end, you can use that data. That's the one part that's very important under GDPR. The other part is, and that's the very new stuff, the permissions already existed under old regulation, but the new stuff is really strong compliance requirements that need to be taken into account concerning your data protection organization, data protection documentation, information, and privacy by design and default. And all these requirements come into play if you look at a target in Europe and want to make sure there's no inherent risks, you will need to look at those compliance with those requirements. There are some more regulations in Europe that you might need to take into account in a transaction, international transaction. The one is the currently negotiated e-privacy regulation. Most of you most likely are familiar with those adorable cookie banners that you find on websites. That's an effect of the still enforced e-privacy directive. This will be replaced in 2018. The European Commission hopes by the same time as the GDPR comes in force. Well, let's see about that. Basically, it addresses any electronic communication and any data used within that, regardless of such data being personal data or not. It does away with the cookie banner, at least in the current drafting. That's the good part. The bad part is it also applies to any messaging services. For instance, WhatsApp would be subject to e-privacy regulation. And using data coming from services under the e-privacy regulation for advertising services will be much, much harder than it used to be in the past. There's also the so-called NIS directive. This is about IT security. It's not about the use of data, but more how you need to protect your IT systems. And this is a directive, meaning it's not applicable universally across the European Union, but needs to be implemented by the member states by local law. Why did data protection become even more important under the GDPR, or will become on 25 May 2018? It's because its fines must be effective, persuasive, and dissuasive if you breach GDPR provisions. And this means the regulation calls for general fines of up to 10 or 20 million euros per breach, and depending on the provision you actually breached. Now, 10 to 20 million is already quite a bit. If you're a large multi-billion company, 10 to 20 million might be a small dent in your earnings, but nothing else. Well, for those large undertakings, the legislator thought, okay, we need to introduce something else, something we already used within antitrust law, and calculating fines by group-wide turnover. So if you're a tiny little subsidiary in one small country did a breach of data protection, which might have been severe, and that tiny little target or company only has a annual turnover of 10 million euros, then, but your company or your group of companies has multi-billion turnover a year, then that multi-billion turnover a year will be the measuring spot for the fines, unfortunately. So this requires you to really pay attention to what is going on data protection-wise in Europe. And with that, back to you, Lisa.
Okay, thank you. All right, and in case you thought Europe was it, no. These laws really are in place in many, many jurisdictions globally. I focused on the next couple of slides, and this one on data transfer restrictions and geographic restrictions, but the comprehensive nature of the laws in these jurisdictions that are on the next couple of slides really are very similar to the European regime in their sort of base requirements. So the central requirements that we just heard about are really found in many of these other laws. Just to pick a few here on this slide, Asia has a panoply of comprehensive data protection laws. In China, the new cybersecurity law that went into effect just earlier this year includes restrictions on cross-border transfers of personal information. It requires notice and consent with respect to those transfers in certain circumstances, and also in certain circumstances requires that entities conduct a security assessment prior to those transfers. So that's a very significant obligation. There is also a data localization requirement in the new Chinese cybersecurity law, and it requires that critical information infrastructure providers store their personal information and quote-unquote important data, yet to be defined, within China unless their business requires them to store that data overseas and they have passed a security assessment. So these are, if you are doing business in China and haven't focused on the new Chinese cybersecurity law, I would urge you to do so, both in the context of transactions and outside the context of transactions, because this is going to be a very significant global mandate. Also, having a data localization requirement is Indonesia. And in Indonesia, there's a requirement that companies that provide Internet-enabled services directly to consumers need to locate their data centers in Indonesia. And these are just examples. There are other jurisdictions as well with data localization requirements and certainly data transfer requirements. Japan also amended its law recently and limits the permitted transfers of personal data outside of Japan to countries that are designated as having acceptable protections for personal data or to third parties that enter into a data transfer agreement or with consent. Malaysia as well, South Korea as well. So not to belabor the point, but in an M&A transaction or other kind of deal, it is absolutely critical to focus on these issues early on, because if you can't get the data that you expect you will be able to get to either use it, to examine it, to disclose it to service providers, then the deal that you are striking may actually be in jeopardy, or at best the price may be impacted. In Latin America, again, we have a host of countries with comprehensive data protection laws as well as data transfer restrictions. Latin America has the concept in place of habeas data that's unique to that region, and it's really about being able to have access to your own data, and it's a result of the various despotic regimes that had been in place in Latin America over time. But now Latin America has moved beyond habeas data, which is found in the constitutions of many Latin American countries, to a point where many Latin American countries now have comprehensive data protection laws in place. These are just some examples. Argentina is the oldest of them. That really came into effect. It was in the early 2000s, and very much mimics EU data protection law under the directive, not the new GDPR. Other jurisdictions, this is a slide that really just includes the kitchen sink, but also, I would point out that some small countries that one would not necessarily expect to have data protection laws in place, Serbia, Tunisia, Benin, one does find comprehensive data protection laws in those countries. So again, in any transaction that is global, you need to really focus on which countries are at issue and understand early on in the transaction what restrictions, what constraints there are with respect to the use and disclosure and transfer of personal data, and we'll talk a little bit later about some of the protections that one might put in place with respect to personal data. Okay, turning it over.
Thanks very much, Lisa. I wanted to offer a couple of observations from an M&A perspective, from the perspective of a deal lawyer looking at a significant number of transactions, both transactions that are data-focused, data analytics-focused, or technology-focused, to otherwise raise data protection issues in ways that are less direct but nonetheless important. Lisa set up very nicely in the beginning how this links to M&A and how critical it is. I think that that message holds true whether you're looking at a deal that is data or data analytics driven or something that is less directly focused in this space, but nonetheless raises important issues, both from a value and risk and compliance perspective. And these topics can have significant impact, whether on your ability to realize your future business case and justify the price that you're paying for the asset, as well as to monitor your risk profile. That is, whether any of the legacy issues that are coming over with the target business are going to create liabilities that were not modeled, were not insured against, were not otherwise protected against in the contract, to the extent that they are incapable of being protected against in a way that's meaningful from a financial and reputational perspective. And that's a critical point. So, part of the message is that this is not just a due diligence topic. This is a theme that runs across every deal, whether it's data or data analytics focused or more general, and runs across the entire deal life cycle, from the initial strategy work, the desktop ideation, and results in a particular need against which ultimately you decide whether you're going to build, buy, or borrow, all the way through to structuring, due diligence, deal negotiation, integration prep, and then closing and post-closing integration. So, this is a continuing theme and each of these things come up in a unique way at different junctures of the deal. So, for example, if the strategic plan involves on entering new geographic or product markets and new customer demographics, are there new data protection obligations that come with it that increase the global compliance profile and risks and costs of the business as a whole? Lisa talked about data localization requirements. If those exist, do they limit your ability to commercialize data beyond the local market, and therefore, for a global organization, significantly impact value of the transaction? If you switch over to the other end of the spectrum on integration, as a result of due diligence, do you have to do a lot of upgrading, whether on the information security side and technology, or on data privacy compliance, and whether that remediation brings a significant cost element to it that needs to be reflected in the business case. So, these things need to get taken account from the beginning, from the strategy work, and as you think about potential inorganic growth opportunities to meet the strategic needs, and you think about people who you should partner with or who you should potentially acquire or invest in, information security and data privacy profile of those partners should be part of the initial screening before you get into due diligence, before you you take up bandwidth and resources with work that could have been more efficiently utilized. You need to think about the history and the track record of folks that you are thinking of partnering with or buying in that space. And as you advance in the process, the preliminary discussions and due diligence can be a risky process from a data privacy perspective as well. There's going to be a lot of great content on that later in the presentation from my fellow panelists, so I'm not going to spend a lot of time on it, but from a seller's perspective, you got to know who your buyer is. Much like the topic about the buyers we just talked about. If you're a seller, you got to know who your buyer is, who your partners are, because you are going to be potentially turning over sensitive data to it, information that that could be regulated and therefore may not be disclosed or transferred, certainly not freely. And likewise, you got to focus on your broader deal team, so your external advisors and vendors. The whole process is only as good as the weakest link, and even if the principals are buttoned up on how information is going to flow and are confident in their infrastructure around that, if your vendors and your advisors are not, that's likely to be an issue. Due diligence itself has an inherent conflict built into it. Obviously, as a buyer and as a seller, you want full disclosure and full review, but the data privacy piece to it brings in limitations on what can be disclosed or transferred, certainly across border. So it is helpful from that perspective to agree in the NDA how the buyer will handle and transfer data, especially cross-border, for example, from the EU to the U.S., and really figure out if there is personally identifiable information or other in-scope data that is truly meaningful to M&A due diligence. Often, and we'll get to that later, there are ways to work around that at an aggregated or anonymized way that that still gives meaningful input to the M&A investment decision. And look, if this goes sideways, you not only have a risk of a failed M&A process, but as a seller, you have new breaches and liabilities on top of that as a result of the failed M&A process. So that's sort of a lose-lose. And again, as due diligence evolves and iterates and potential data and security risks begin to crystallize, you've got to keep in mind that there are some things that money can't fix. Reputation and PR, contagion to your existing business and global brand and relationships can't really be fixed with indemnities and escrows and price adjustments and integration remediation. In some situations, you may be put in a fairly difficult position of having to model that the question is not whether there was a data problem in the past, but when it may come to light, again, based on your assessment of security, information security weaknesses, for example. And so what the magnitude and probability of that exposure is for your business case. And there's going to be a lot more art and judgment and science to that. I keep talking about information security and data privacy in one phrase. And, in a sense, it's because data privacy, regulatory compliance, and information security controls and technology cannot really be separated when you look at the total risk. So you do need pragmatic legal advice coupled with solid technology expertise. And the last thing I'll mention before I turn it over, and Lisa framed it very nicely, is that, data and the insights that we generate from it is going to be a critical driver, a critical fuel for innovation opportunities. Our CEO called it the new oil, and that's definitely the theme. And with great opportunities, come significant risks, particularly when the space is as evolving and new. And I think Lisa's discussion of evolving regulation, Lisa's and Philip's discussion of evolving regulation underscored that. So you have evolved commercial prospects, but you also have risks of ambiguous and unknowable scale and volatility. So you got to be prepared to live with uncertainty to some extent, however good your due diligence, legal advice, and planning are. And as the field evolves, and this could be into the future, after you bought the business, after you entered a particular geographic market, there are presently unknowable risks and challenges that could materialize. Again, whether because there's some problem with the business that you bought before that wasn't really a problem at the time, because of regulatory or political developments. The space has been event-driven to a significant extent and will continue to be, like many evolving things, black swan events, so things that we can't even anticipate at this point. So I think there's a lot of focus and a lot of courage that you have to go into the process with, but there are great opportunities and challenges that need to be approached thoughtfully. And with that, I'll turn it over.
All right, thank you, Alan. Yeah, if we look on all this, what we just heard, and how does it impact M&A transactions? First of all, we need to think about applicable law. Many people just think, and if I've heard that in transactions, be it M&A transactions or contract negotiations that had a multinational aspect to it, it's oh, this doesn't matter. It's just we'll make whatever, I don't know, laws of England and Wales or Californian law, applicable law, and then we don't have to worry about it. It doesn't work that way with data protection laws. In so far, data protection is similar to, for instance, IP law in that it has a territoriality principle. Basically, for Europe, the GDPR will apply to any data subjects that you're doing business with that are situated in Europe, regardless of you being established here in Europe or your company being established in Europe. If you have an establishment in Europe and handling personal data, even if it's not personal data of European citizens, it's still going to be European regulation applying to that data. So you need to look at where is the data and who are the data subjects that are within those databases to really define applicable law. And you cannot stipulate out of the territoriality principle. It applies by law regardless of any contractual clauses you put into that. What does it mean? Really, you need to look at where is the data and who are the data subjects, the people that the data refers to. Of course, you need to do that under personal data protection laws, but you also need to do that because of all the localization laws that Lisa mentioned earlier, because you need to know what do I need to do with that data that needs to be localized when I transfer it in a multinational group of companies, or want to transfer it that way. Even within the European Union, where we now happily say, hey, we have a unified data protection law in the GDPR. Well, yes, we do, but there are aspects that the GDPR provides flexibility clauses for where the member states can do their own legislation. For instance, personal data used in an HR context. This is still under national regulation. Germany implemented national laws for that. I believe the Austrian new law has some as well, and France will do so as well once they implement once they pass their GDPR implementation law. Also, in the first, let's say, 5 to 10 years, we will likely have different local practice by the data protection authorities. The same question might be handled differently until everything is finally truly harmonized by way of the European courts. So you will, in Europe, already need local counsel, most likely, in the different countries. And of course, if it's a worldwide transaction with targets anywhere or with data of citizens of countries all over the world, you will likely need to involve legal experts or data protection experts for all of these countries. Now, if we look at the impact on the different sides on a transaction, Ellen already talked a little bit about that. I'm not addressing again on how do I need to bind the buyer to certain standards, and already said that. But on the seller side, you also need to look at how do I prepare my data room. In the past, when I began my practice, it was just any data was in the data room. At that time, it was still on paper, but still was any data, and it was usually not redacted at all. Then, depending on where compliance was more important, either antitrust concerns or data protection concerns came up, and people started redacting the documents in the data room. For antitrust, this is quite common that you redact the commercial data or other market-sensitive data. With the new fines, it's almost even more important to do that data protection-wise. You will not want to have any personal data unredacted in any documents in the data room normally. There might be some exceptions like the names of the managing directors, but these are most likely public data anyways. But other than that, all personal data that might be within contracts, that might be within organizational charts, and so on and so forth, they need to be redacted. And you cannot contain any names and all that in the data room, at least in the very first phase. We might talk a little bit differently, or think a little bit differently about that between signing and closing, but initially that's a no-go, and that's potentially a fine under the GDPR. On buyer side, you of course need to take into account the various risks that the transaction might bring with it. Of course, the primary risks are those that might affect the target value, plus being compliance risk as well. The target value often, as Lisa already explained with the WhatsApp example, is determined by what kind of personal data does the target have and how can I use it. Well, having personal data is a good thing, but the more important question is, am I actually allowed to use that personal data? I talked earlier about the permissions that are required for use. So you will need to take a look at how is the data generated and for what purposes, and what is available if not the execution of contract or compliance purposes are sufficient. So you will need to look at, is the consent that the data subject gave valid? Yes, of course, you cannot look at every consent of thousands of users, but you can look at the example consent declarations that the target uses, or are other legal permissions valid, like the legitimate interest. You will need to take a close look at what is legitimate interest and can you balance it against the data subject interests. If those legal permissions do not apply, you cannot use that personal data. Concerning GDPR, you may likely have read any newsletters that 40 to 60% of your personal data is worthless once GDPR is fully applicable because consent are not valid anymore. I'm not fully buying into that number, but there's a certain risk that a significant amount of personal data actually may not be used anymore. That's very true. The secondary risks are mostly compliance risks. I said earlier that under GDPR, the compliance requirements for companies are much, much higher. That's mostly on the organizational part. Easiest to determine is there a data protection officer required, and if so, is he or she appointed? But more importantly, it is to look really at the business processes. How do they use personal data in their everyday business, and what standard of use of personal data is implemented? Is it described somewhere? Is it documented? How is data protected? All that concerns GDPR compliance nowadays. Is data protection generally taken into account when archiving or storing information? You may not store personal data forever. There's only a need to know, and for the time that it is necessary that the data can be stored. So you need to look at archiving concepts. You need to look at how are the data subject's rights upheld. So is there a process for giving information to data subjects? Is there a process for data portability, and so on? You will really need to look at all this. And in an international context, you will also need to look at how are currently data transferred between the European Union and other areas of the world, or where localization requirements are from there to other areas of the world. For Europe, if you transfer data into the US, the easiest ways are privacy shield or standard contractual clauses. But of course, you will need to look at if these require, if the standards set up by privacy shield and standard contractual clauses are complied with. Now, if you've identified any risks, you really need to look at, can I mitigate those risks? As Ellen said, some risks cannot be dealt with with money. The fines that are under the GDPR, usually they might not be covered by the limitation of liability under the deal. So you will need to look at that under reps and warranties. And the other part is, if they can be mitigated, when do I need to do that? Lots of the compliance stuff most likely will need to be mitigated before closing. Some can be mitigated afterwards. So you might need to think about closing conditions and similar things to mitigate the risks. If it's really, can I use personal data or not, it might be simply value driven. It might drive down the acquisition price. And with that, I'm happy to turn over to the next speaker.
Thanks, Philip. So talking about, the mitigation of risks kind of is a good transition into these slides. So if you're, a buying organization or representing somebody purchasing an organization, there's a couple high-level things that, are good steps to kind of put in place or do kind of at the beginning to kind of just get a feel for, everybody's in the environment that you're stepping into. So one way to have that confidence in your review is to determine a formal security review team. This could be a team that you've crafted internally, or maybe a firm that you're contracting with, that you've defined maybe some agreed upon review procedures, scoring, but, kind of going back to what was talked about earlier with the various factors of a deal is some of these should be left open-ended so you can account for the variability. And then once you've done your due diligence, another good step is for that security team to actually get in contact with the organization that's being acquired potentially and actually meet with their security staff. Discuss the potential breaches and issues that have maybe occurred in their company before. What remediation plans they took, or significant weaknesses that they've seen. Understand their infrastructure a little better, the security measures that are in place. How are they encrypting their data? How are they storing it? How are they tracking different factors? And then also another good area is the operational and just security procedures that are in place. Incident response, privacy, breach notification. From those discussions, it'll help you determine the maturity of the security infrastructure and maybe the effort to remediate, or, help you determine how you want to handle this organization's infrastructure. Maybe you bring it in-house. Maybe you leave it segregated. But, do you want to maybe go in there with your security team and fix these problems, or recommend them to hire a consultant? And then finally, just understand and get a feel for how good their security team is. Do you really trust them? Are they providing you reasonable, proper feedback? Or, are they just saying, yeah, to get the deal done? But then, from the seller side, well, this company wants to buy us. That's great. But, are they the real deal? Are they going to cause us problems? So some things you might want to understand in this process before you start to pass over data, that's the lifeline of your business and could put you at risk for major fines, is what data protection procedures do they have in place? What do they, how do they plan to handle the data or share it? When do they plan to discard the data, and how will that be confirmed back to you, should the deal fail? Or, maybe it's just not needed because at the end of the process, you determine you want to have the entities separate. What security audits have taken place? Do they do risk assessments, privacy assessments? It's almost like interviewing the interviewer in this sense. So then you have that comfort that, this other organization is going to live up to the same requirements and the same standards they're asking you to. And then finally, kind of going back to something I believe Philip mentioned with the data room and the data protection is, are you even comfortable that how they're asking you to share this information is appropriate? Is it going to be stored securely? So you might want to do some due diligence around those areas, kind of get a feel for what they're doing, and then if you're not comfortable, maybe provide them access to a spot, that you're comfortable with to review that information. So then I believe this is Lisa?
This is Lisa. All right, thank you. Well, so we've talked a lot about this, and so just building on the comments that have already been made, I think it goes without question that due diligence into privacy and security issues is absolutely critical, and it may be just as crucial to a deal as understanding the target's financial status, because this kind of due diligence could reveal issues that go to the heart of pricing or even the viability of a deal altogether. So you could discover, for example, that the data that you thought you could use, the customer data you thought you could use for marketing purposes, in fact, can't be used, and that would be, of course, rather a deal killer. Acquiring companies need to prepare a comprehensive due diligence checklist asking pointed questions about privacy and security issues and requiring related materials. And here on this slide are some of the types of materials that might be requested, and we've done a lot of listings, so I won't belabor the point, but we need to think about privacy policies in every jurisdiction, information security policies, and now there are laws in many jurisdictions that require certain information security standards, and this is reasonably new. So we need to think about whether the existing policies integrate the various global rules. How is the incident response plan? Is it state-of-the-art? Does it integrate now the newer and unfortunate 72-hour notice periods that we're seeing pop up in places like the Philippines, in New York for financial services companies, and soon in the European Union under the GDPR. How is privacy and information training? Is it pretty good? Is it pretty strong? What service providers are used? Service providers are a huge source of vulnerability, both on the privacy side and the security side. So it's absolutely critical that service providers be assessed. And of course, a review of any risk assessments that were done is crucial, and data transfer documentation needs to be visited as well. And here are some key due diligence questions that you might think about integrating into a diligence checklist. And I've put some questions here and on the next slide just to quickly review them. What data are we talking about here? What data is collected? What data is disclosed? Are the contracts with service providers or the recipients of the data compliant with legal requirements globally? Where is data stored? What security is in place? Is there a dedicated employee for this area? And this is a question that I will highlight. I have one client who says, I only need to know one thing about an acquisition target. Is there an employee dedicated to privacy, and is there an employee dedicated to security? And if I know that somebody's job is going to be on the line for failure to comply or failure to safeguard data, then that takes care of 80% of the battle for me. So I think that's one to highlight. We've talked about transfer significantly. Is the company subject to any kind of government investigations or violations of law, or has the company suffered data breaches? And I just want to note here that if the company has suffered a data breach, that is not the be-all, end-all. The question really in my mind is, how well did the company manage it? Because that's the make-or-break question. Okay, turning it over.
Thank you, Lisa. And yeah, if you find any risks because of your due diligence, or generally if you look at how do I structure a deal, you really should think two ways. I mean, typically there's either going to be a share deal, you're going to take over a majority of the target, or there's going to be an asset deal. You take over the major assets or all of the assets of the target. The difference really is concerning how can I use the data, or how actually can I make sure that I get the data that I want. With a share deal, that's not really the big issue. The legal entity stays the same if you do a share deal, but at the same time also the risks stay the same. So any risks that were in the target company, compliance risks, they will be kept and they will be upheld, and you need to mitigate them by closing conditions or by making changes once you acquire the target. If you do an asset deal, you can put away most of the risk in there. I mean, you still have the risk, can I actually use the data that is there or not? But then you need to think about, well, if I do an asset deal, the data that I'm acquiring is actually being transferred from the target to the new acquiring entity. That's a transfer under data protection laws, and do I have legal permission for that transfer? Usually you will do, but there's always a risk that some of the data subjects will object to such a transfer of data, and that you will not get all of the data that might be there in the target. Then you need to assess, well, is it enough if I get, let's say, 50, 60, or 70% of the data, or do I need all of the data? Then an asset deal might not be the right way for you to do that. Further, in terms of deal structure, you will also need to look, in particular when you're thinking about an asset deal or when you're thinking about a share deal but want to centralize some of the data within your headquarters, do I transmit data across borders? Of course, within the European Union, or actually the European Economic Area, that is no issue. But if you're transferring it to the US from Europe, or to Asia, or potentially elsewhere where localization requirements are there, you always need to take this into account. We talked about this earlier. I just want to highlight briefly on the European Union system, or European system of data transfers. Most of my clients say, hey, I just use Privacy Shield, I implement standard contractual clauses, and that should be it. Can you help me with that? And we're very happy to help with the standard contractual clauses or Privacy Shield compliance, but that's only the second part of the question. The first question is, what data is transferred and why? Most of the clients tell me because the headquarter wants it. That's a good operational and business reason. It's not a sufficient reason under data protection law. So you really need to look what data is transferred and why, and then if you find a legal permission for that transfer, then you need to look at how do I safeguard data protection securities, such as using Privacy Shield, which is going to be unlikely in the M&A context, but might be relevant in the integration, or standard contractual clauses. In some exceptional cases, there might be consent, but that's only really practical if there's very limited number of personal data and data subjects involved. And with that, we go on to deal documents.
Okay, and that's me. So, the transaction documents really need to contain detailed provisions concerning privacy and security issues to minimize surprises after the agreement's been signed and after the deal closes. We need to consider always how to best apportion the financial risk between the parties, and we do that through the deal documents. So typically, we would see these sorts of documents containing fairly significant privacy and data security representations and warranties. The thing that we see missing most, though, are provisions covering global issues, and some, as you've heard through this panel today, are very onerous and difficult to manage. So to deal with them prior to the deal closing in the documents is absolutely appropriate. We always expect there to be a disclosure schedule listing exceptions. Nobody's perfect. All we can ask is for reasonable compliance and safeguards, and so any exceptions really should be listed. Material exceptions should be listed on a schedule, and the acquiring party needs to understand and absorb the risk associated with those exceptions. The acquiring entity might, for example, ask a target to take on specific remedial steps pre-closing. So these could include complying with a data protection law compliance plan, developing safeguards to protect information that go above and beyond what is already in place, encrypting devices. You know, most entities now encrypt devices, but sometimes we still see many that don't, some that don't encrypt all mobile devices. And then revising privacy policies is also fairly critical because if a privacy policy says that data will not be used for X purpose, but the acquiring entity specifically wants to use data for X purpose, now is the time to change the language and allow, or at least satisfy some of the legal requirements depending on jurisdiction around providing appropriate notice and obtaining consent. As I mentioned, considering how to best apportion risk is key, and indemnities and holdbacks like escrow accounts are often used to handle these issues and any issues that may occur post-closing. The key is to make sure that any holdbacks are sufficient to manage these issues, and this is only done through appropriate diligence. I'll note that in negotiating survival periods for these measures, it's important to consider how long system integration might take, and also limitations for privacy and cybersecurity claims. Having all of these measures in place in advance will absolutely help to manage the parties' privacy and security exposure. Next speaker.
So, a little more on data-driven deals from a European perspective concerning non-personal data. We spoke today a lot about personal data and how can that be used and protected, and what do you need to take into account in a deal. Some deals might actually be non-personal data-driven. If you want to have access to a target that has lots of sensor data, machine data, Internet of Things data, a lot of that data will be personal because it's possible by metadata or other methods to identify a person, but there are also quite a few amount of data that's non-personal. Of course, data protection regulations will likely not apply to those, but you might think about how can I use it and how can I protect it? Well, generally, just very briefly on that topic, there's no ownership of data, non-personal data. Anyone that has access to it generally can use it. That's at least the case for raw data. Once it's assembled and structured, it's a database, and it might be protected under neighboring rights, similar to copyright, but that doesn't apply for raw data. In the future, or in some countries, it might already be protected as trade secrets. You will need to look into that if you find protection from that. For instance, in Germany, currently, that is the case, but trade secrets in Germany, you can not easily ban a third party from using that data even if they acquired it unlawfully, other than in other countries. That will change with the implementation of the Trade Secret Directive next year in the various member states, but you will need to look at that when you think about protecting non-personal data. And you can, of course, similar to IP licenses, also create civil law licenses on data, but there's no absolute rights such as IP yet on non-personal data, and you might need to take that into account when assessing value of data and how can you protect it in the future. And then over to the next speaker.
Okay. So look, we're running out of time. We have 2 minutes, so very, very quickly. After the closing, the acquiring company should immediately pursue a plan to address privacy and security issues that need remediation, and certainly one would want to prioritize higher risk issues. There are many pitfalls. For example, merging systems in a way that won't compromise the security of either system, and at the same time ensuring that employees can effectively collaborate across networks is absolutely a challenge. We need to understand the risks before we enter into a deal. craft appropriate terms, as we said. Insurance might be a very useful tool here and certainly should be looked at. It's again, just a risk-shifting mechanism that could provide the right backstop. And boards of directors, without question, should be very specifically schooled on relevant privacy and data security issues.
So some actionable items that can be taken from the buyer side to help ensure, as successful as a process and deal as possible would be, one is to actually just require a data security and privacy requirement within your M&A, SOP. So it's actually a line item that has to be knocked out. So then it raises its, the importance in the organization. So one kind of good area that Philip mentioned earlier is, why are we needing this information? So a process should be developed to actually review, classify, and quantify the data that's expected to be received, determine key risk rankings, the category, and the value. So then you can say, okay, this data is worth X amount of dollars from a risk standpoint. Develop significant data handling procedures if you don't already have some in place. Because based on the type of information that's going to be received, there's, definitely very, specific prescribed requirements on the security scope and what needs to be handled. Is something in there that's going to actually end up killing the deal? What kind of data, segregation should be in place? Define any other requirements. As Lisa talked about earlier, require due diligence procedures that are specific to security. And then another important one, I think, is to actually get the approval and sign-off from upper management that these procedures were taken properly and they agree with the findings. So then everybody throughout the organization is on the same page, and there's no one that can say that they weren't made aware of, what was going to happen. And then the next step would be obviously to ensure secure storage environments. Some additional steps besides just saying, okay, we're going to put information here is review access permissions to those locations, make sure there's no cross-contamination of client data or access, review backup procedures to know where data is going to land, so you're not ending up backing up and retaining somebody's information indefinitely that you're not supposed to anymore, and then just reviewing any, general compliance documents. And then on the seller side, putting good IT policies and procedures in place up front. Obviously, if you don't want to spend a bunch of money, it may not be something you want to do from a seller standpoint, but it can obviously help to kind of make the deal go a little quicker and easier because you're knocking out a couple key concerns for your acquirers. So implementing baseline IT security controls, understanding where your significant data resides, what kind of information is it, are user access reviews taking place, check out the key applications and systems, data storage locations, any third-party SaaS applications or services that are being used, Google Drive, Amazon, things of that nature, any kind of access removal and approval procedures, ensure things are documented, review access logs, ensure there's perimeter defenses in place, data encryption, and then obviously, a privacy impact assessment on your data, performing vulnerability assessments and penetration testing, assigning a data protection officer, implementing data transfer and review procedures, review any kind of data export categorization and sanitization procedures that you might have in place for when transferring info. Any kind of approvals before transferring significant data sets that might want to be put in place. And then obviously some kind of data confidentiality NDA type agreements with potential buyers are going to be transferring information with. And then on the buyer side, when it comes to internal audits, you might want to develop a good internal audit program, so then you can use that information to then be used to review these other organizations that you're potentially acquiring to get a handle on, so you can have a more one-to-one comparison. You know what you're doing, so then this other organization up to par. You might want to do some dry runs of some of your own procedures just in case anything goes wrong. And then sellers might want to have, some third-party audits in place, like a SOC 1, SOC 2, ISO, high trust, PCI, just kind of depending on what type of data that they're managing. some key types of data to keep in mind when reviewing is PHI, PII, personal financial information, any kind of credit card or banking records, classified government or defense-related information, information on children, arrest, divorce, or other legal records that might be used in processing, and then work history, personnel files, and kind of other private records that you may be storing, even in personnel files. And then some strategies would be privacy by design. You want to obtain, and transfer out the minimum possible, encrypt, tokenize key information, privacy by default, understanding the information you're going to be collected and cutting it off up front so that you're not obtaining too much, and then obviously just limiting the data scope to the smallest subset possible during the initial M&A process, so then only key and significant information is transferred, so then you can reduce the amount of risk that you're introducing to the process.
Great, so we have come to the end of our time. We don't unfortunately have time for questions today, but do any of our speakers want to make any conclusion remarks before I close the program for you? All right, well then I'll go ahead and close out the webinar. Thank you very much for your presentation. I hope everyone found today's discussion to be helpful and insightful. You can register for future Bloomberg BNA webinars by accessing our store at www.bna.com/learning. You will currently see instructions on how to earn credits for attending today's webinar. Please go to learning.bna.com to retrieve your certificate. CLE certificates may take 4 to 6 weeks to appear depending on the jurisdiction requested. If you have any questions about continuing education credits, please email us at credits@bna.com. Finally, I want to again thank our speakers and World Services Group for putting together today's presentation. Thanks everyone and enjoy the rest of your day.